Baker Botts, LLP, provides podcasts for educational purposes only. They are not legal advice and are not intended to establish an attorney client relationship. This communication may constitute attorney advertising.
Welcome to AI Council Code. The AI Council Code is here to keep you up to date on all AI legal issues arising in the modern business frontier. I'm your host, Maggie Welsh, and today we're going to be talking about the SEC and disclosure requirements related to AI. AI has become such a buzzword over the last 2 or 3 years, and more companies are talking about AI in their disclosures to investors. So, today we're going to talk about what a company should be thinking about in terms of its SEC disclosures related to AI, and also what a company has to watch out for in terms of overstating AI use within the company. So, today we're joined by John Lawrence, who's a partner at Baker Botts. Hi, John. Why don't you introduce yourselves for our listeners?
Hi, Maggie. Thanks for having me. I am John Lawrence. I am a trial partner in our Dallas office here at Baker Botts. I've got a varied trial practice, and a part of that practice is defending companies and officers and directors in securities and shareholder litigation. And I think really as a result of that experience I've had defending clients in those matters, I've also ended up gaining a part of my practice of advising companies and boards on securities issues, hopefully before litigation commences, including issues related to disclosure requirements.
Great. Thanks, John, for being with us. So, to start off, when we talk about AI and SEC disclosures, what types of companies need to be thinking about AI disclosures?
From an SEC perspective, it's really any company seeking public investment through a security. And so public companies, publicly traded companies are obviously one of the biggest examples of that and biggest buckets of people who should be thinking about this. But it also includes private companies that sell securities for investment, whether that's stocks or membership interests or debt or convertible notes. All those companies are going to be regulated by the SEC and fall under these rules. And then so the next question becomes which of those companies should be thinking about AI disclosures? And I think the answer is really all of them. Not all of them will be making AI disclosures, but in the world we live in today, where I think every company is talking internally about AI and thinking about it, thinking about your AI disclosures and whether you have a need to disclose should be part of that conversation. You're going to have some companies that are themselves in the business of developing AI apps. Those companies would be pretty obvious candidates to be making disclosures about AI. You'll have other companies that may just use AI tools in their own operations. And then you'll have other companies that aren't using AI at all, but they may still have risks that they are subject to because of AI, whether that's cybersecurity related risks or competition related risks. And really, all of those companies should at least be considering whether or not an AI disclosure is appropriate. There was a study recently after this last round of 10Ks that said that nearly 2/3 of all S&P 500 companies mentioned AI in their 10Ks this past year, which I think says a lot. 2/3 is not just tech companies, it's all sorts of companies. After seeing that, I went in and looked and tried to find examples of who I thought wasn't going to be talking about AI. And I picked two and I looked at their 10Ks. One was Campbell's Soup Company. They talked about AI. And one was J.M. Smucker Company, who also talked about AI twice in their disclosure. And so I think that says something that if the people who are selling you soup and selling you jelly and other products are thinking about how to disclose AI related risks and opportunities in their 10Ks, there probably isn't an industry out there that shouldn't at least be considering whether or not this is a disclosure that should be in their filings.
That's really interesting study of the two-thirds of the S&P 500 mentioned AI in their 10Ks. That is a large majority of them, and I assume that number has probably increased over the last year or two. Is that right?
Yeah, it has. I don't know the numbers from 2 or 3 years back, but I do know that it has grown quickly. And my guess is that the number will grow further this next coming year.
So you mentioned AI disclosures, and just to level set for everyone, what do you mean when you're talking about AI disclosures, and how are AI disclosures different from other disclosures that a company might put into their SEC filings?
So I think in the bucket of what are AI disclosures would really be any disclosure talking about your company's risks or opportunities or operations that relate to AI. And in terms of how they're different from other disclosures, really other than the fact that they have the words AI in them, they're not that different on a fundamental level. AI is obviously the next big thing, and it may be the biggest next big thing that's happened in the last 50 years. But the securities laws are more than 90 years old now. They've covered a lot of next big things in their almost century of life. Commercial aviation has grown and flourished, and the impact that's had on business has all happened under the current disclosure regime. We've added computers and digital media. We've had satellites in space. We've had the internet, lots of things that have had immense impacts on companies and presented real opportunities and risks to those companies have all been covered by these same disclosure rules. So I think at bottom, they're not different. There are the same block and tackle issues that you deal with on any other disclosure issue. You need to make sure that you're making full and fair disclosure of information that's material to an investor's decision whether or not to invest. And where you are making statements to investors about AI, you need to make sure that those statements are not materially false or misleading. And so it's really not that they're different from a legal perspective. There aren't, as of yet, new rules about these disclosures. But what I think Gary Gensler, who's the SEC chair, said in a speech earlier this year hits the nail on the head. And he said that the way he's thinking about it and the way the SEC is thinking about it is that AI raises a host of issues that aren't new, but are accentuated by AI. And some of those issues have to do with just the technology itself. I think we've all learned a lot about AI over the last 1, 2, 3 years, especially over the last year and a half. AI has immense capabilities that are only growing, but AI also has lots of limitations and risks. And those limitations and risks are maybe different than the limitations and risks in other arenas because they're not well understood, even by people who are seemingly talking intelligently about AI. And so just the fact that the technology itself is maybe a technology that's harder to not just understand, but harder to speak about in a clear way makes it maybe more likely that there could be confusion for an investor in reviewing AI related disclosures. And then some of the issues that I think are causing this to be a hot issue for disclosure law right now just have to do with the fact that it's really buzzworthy, right? Anything that creates a buzz is a good thing if you're trying to get somebody to invest in your stock, but it's also something that for probably millennia has also been a source of fraud and of people misunderstanding and investing in something that they didn't fully understand what they were investing in. So I think the SEC really just sees a danger in companies either failing to disclose their AI-related risks or of disclosing their AI-related opportunities or risks in a way that is misleading to investors, whether that's because in an extreme example, somebody is trying to mislead investors, but in probably the more typical example where somebody is not being as clear as the SEC would like them to be, even if not in an intentional way, but in a way that could cause investors to misunderstand or misappreciate the risks or opportunities related to AI that a company is talking about. And so that's, I think, really why it's become, in the last several months, a real focus of the SEC to be looking at these disclosures.
Let's talk about that focus. Can you explain the SEC's focus in the last couple of months? What are they doing in terms of AI disclosures?
I think taking a step back, it's helpful to understand that there are really two divisions within the SEC that are looking at these disclosures and that are focused on not just AI disclosures, but on all disclosures. One of those divisions is the Division of Corporate Finance. And that's the division that is proactively looking at companies' disclosures. If you're a public company, by law, once every 3 years, the Division of Corporate Finance is looking at all of your disclosures, and they may be sending you comments on those disclosures. And then there's also the Division of Enforcement, which name tells you what it does. It's the body within the SEC that's investigating potential violations of these laws and bringing enforcement actions against entities or individuals that it believes violated those laws. And both of those different entities, both the proactively looking Division of Corporate Finance and the Division of Enforcement, have both said in the last year that they are making AI-related disclosures in particular something that they will be looking at more closely starting now and going forward.
And so these two divisions, have they really explained or articulated what they're looking for in terms of these disclosures?
Yeah, to their credit, the SEC, I think, typically does a good job of trying to explain what they're looking for and to be helpful to make sure that they are giving the guidance necessary to help companies do it right to begin with. And so the director of the corporate finance division actually gave a speech earlier this summer where he outlined a list of 4 things his staff is going to be looking for and considering when they are reviewing disclosures about AI. First, they're going to be looking at, is this disclosure focused on the company's current or proposed use of AI rather than some kind of buzzworthy use of the word AI? So really looking at, is this disclosure actually tied to something the company is doing with AI as opposed to just being more of a marketing buzzworthy disclosure? The second thing he said that they're going to be looking for is, does the disclosure clearly define what it means by AI? That's something I think we've all dealt with. Is AI is a broad term. and it can mean lots of different things. There's lots of different AI related technologies. And I think the SEC has identified that the potential confusion between those technologies and what different technologies are actually doing could be a source of confusion for investors if they're not explained clearly what is the technology that's being talked about in these disclosures. And so that's the second thing they're going to be looking for. The third thing that the Division of Corporate Finance is looking for is, does the company have a reasonable basis for its claims? So do the facts actually support what you're saying based on the facts the SEC knows? Does it look like the facts will actually support the disclosure about your AI related risks or capabilities? And then the last thing that they're going to be looking for is the disclosure of these AI related risks or capabilities actually tailored to the company, or is it really just more boilerplate? I think sometimes boilerplates get a bad rap. There's room in people's disclosures for disclosures that may appear more boilerplate. And I think the SEC understands that. And if you're a company that your entire business is AI, you probably need more detailed and more tailored to your company disclosures about AI. Lots of other companies may end up with disclosures that look similar to each other. And so the level of detail that they'll be looking for in terms of your disclosures will really depend somewhat on what is the material impact of AI on your company and how does that inform the level of disclosure and the type of disclosure you should be giving. And so that's what the Division of Corporate Finance has helpfully said they will be looking for in terms of helping to guide companies as they're making these disclosures. And the chair of enforcement has also made clear that this is a focus for his staff this year. He said it in speeches, but actions speak louder than words. And he's also said it through a handful of enforcement actions this year already that his staff have filed against individuals who they have accused of AI washing. AI washing being a term that is used to mean either you say you're using AI when you're not really using AI, and that would be obviously a pretty extreme example of lying to investors to say you're using AI when you're not. It also refers to instances where you may be saying you're using AI in a particular way, but you're not really doing it in that way. And so that again goes back to what the Division of Corporate Finance said about making sure that you're accurately describing what you're doing. And so we've already seen this year 2 different enforcement actions against investment advisors who said that they were using AI to help make investment decisions when the SEC alleged that they were not in the way that they described. And those advisors ended up entering into consent orders. And then we've also seen another AI related enforcement action brought by the SEC a couple of months ago, where the SEC alleges that a founder of a private company raised almost $30 million from investors, telling them that the company used AI in a certain way. But according to the SEC, this platform did not actually use AI in the way that it said, and the technology that it said it used was not as advanced as was represented. And so those are the sorts of allegations I think we're going to be seeing in enforcement actions going forward. It's what both regulators and plaintiffs' lawyers are looking for, which is companies either overselling their AI-related capabilities or underselling their AI-related risks. And then when that's found out, or when somebody thinks they found that out, bringing an action.
Interesting. Definitely something to watch in the SEC enforcement perspective, and I could see that developing a lot in the upcoming months and years. You mentioned plaintiffs' lawyers, so have there been private shareholder suits as well?
Yeah, there have been. There were some last year, and there have already been several this year. And I think that's going to just continue to grow over the next couple of years and maybe be around for a long time. The theory of those private suits is going to be similar to the SEC actions I mentioned. Some company is going to make some disclosure next month about something related to AI. After that disclosure, people are going to buy stock in that company. And then at some point a year from now, something will happen where a stockholder says, I think you misled me about what you told me and the rest of the market about your AI capabilities or risks back 4 quarters ago. And the stock price dropped, and now I'm suing.
So, for a company looking to navigate these AI disclosure requirements, what advice would you give to them?
So I think a lot of it's probably things that the companies are already doing. At least the building blocks of it are already there. I think we've all seen just from the number of conferences we've been invited to or emails we've gotten about CLEs or talks that AI is something everybody's talking about. And I think that inside companies, that's the same. I think lots of companies are already having discussions internally about what does AI mean for us? Are we using AI? Should we be using AI? What risks does it present? How are we using it? And as part of those talks, I know lots of companies are already bringing in internal and external experts to talk to the C-suite and talk to the board about those issues. And so that's really step one for the disclosure discussion too, is making sure you have a good understanding of what are you doing with AI? What do you think you'll be doing with AI? What are your competitors doing with AI? what risks do you have as a result of either your use of AI or others' use of AI, and making sure you understand those things well. And once you've done that, which again, I think people are already doing, regardless of any disclosure requirements, it's then a matter of taking that and making sure you've got good processes in place to ensure that your disclosures are adequately describing those opportunities and risks if required. I mean, I think the stat about 2/3 of the S&P giving disclosures last year is a great stat, and it's a big number. But I also think we need to remember that 1/3 of them didn't. And I don't think those companies necessarily did anything wrong. I think there's a discussion to be had in every company about whether to disclose. And I think some companies will rightly conclude they don't need to, but you need to have that process in place to make sure that you are considering it and deciding whether or not, under the existing securities laws, disclosure is required. And if you are disclosing something about AI, making sure that you're not being misleading.
Very interesting. Thank you, John, and thank you for your insight. Something to keep a close watch on for sure. And thank you to our listeners for listening to the AI Council Code. We're so glad that you joined us today. Stay tuned for additional podcasts and more insights on AI legal issues.
Thank you for listening to this BakerBots podcast. BakerBots has the experience, knowledge, and people to address our clients' most significant legal issues. For more information on BakerBots practices, please visit us at bakerbots.com. This presentation is provided by BakerBots LLP for educational and informational purposes only. It is not legal advice and is not intended to establish an attorney-client relationship. Under the rules of certain jurisdictions, this communication may constitute attorney advertising.